seems to be the court is very interested in administrative law, specifically gun law or administrative law related to guns, the ATF. And so they've taken up this new case on what, colloquially people would call the Biden ghost gun ban. If you want to be a bit more technical, it's actually a regulation on the sale of unfinished firearm frames and receivers. And recently we had the court in the Fifth Circuit, a district court, ruled that this rule violated the law because it expanded the ATF's power beyond what is allowed under the statute. And so it violated the Administrative Procedures Act. And the 3-judge panel in the Fifth Circuit agreed with the lower court. And now the government has appealed this to the Supreme Court, and they've agreed to take it up. Can you just give us a little bit of breakdown on where this case stands and what it means for the Supreme Court to take it up?
Sure. So, two things. Initially, when the district court had found that the regulation redefining or expanding the definition of firearms and a frame and receiver, and those are, we'll get into, I'm sure, it did both of those things. And legally, what the ATF did with each is distinct, perhaps in a meaningful way. District court enjoined the rule as a whole. The Fifth Circuit narrowed that some. There's a big question in a lot of these cases about when an agency issues a regulation that has a problem and a court finds a problem with it. Do you invalidate the entire regulation, or you just invalidate the parts that were challenged and that are a problem? There's a second question about to what extent do you provide relief beyond the parties to the case? And these are issues that the court has been dealing with quite a bit of late. Initially, the federal government went to the Supreme Court asking for a stay of the injunction, so allow the regulation to go into force while the litigation proceeds. The court
right, because the lower courts denied that. Right? They said, no, you're not getting a stay. Yeah. This is being vacated completely for everyone. Right. That was the first step here. And then they went to the Supreme Court.
Right. They went to the Supreme Court, and the Supreme Court took a little bit of time to decide on that, ultimately granted it, but 4 justices, Thomas, Gorsuch, Kavanaugh, and Alito, indicated that they would not have granted that temporary relief, which suggests either that they're skeptical of the government's arguments, or perhaps that insofar as the Fifth Circuit narrowed the injunction to some extent, that dealt with what the court should be concerned with for now. But I think the former is more likely. So a hint, at least, that 4 justices are skeptical. The Justice Department asked the Supreme Court to hear the case, filed a petition.
Well, didn't it go through there were like 2 rounds here, because there was the initial phase where they issued that stay where they had the noted dissents. And that was just on what on that broader expanded view of vacation of the rule and applying to everyone. Then it went back to the Fifth Circuit panel, and they, I think, then it went all the way back to the district court. Wasn't there a decision on the merits?
Yeah.
At that point?
Right. So it went back. They
kind of did this whole thing over again.
Fifth Circuit affirmed in part and vacated in part, and
that's when the Fifth Circuit tried to narrow the ruling a bit.
Right. And now the court as a great,
but the court still wasn't happy with that. Right?
No.
Right.
And what's interesting is the court has only taken 4 cases for next term. The court takes, what's interesting, just to step back for a second, after District of Columbia versus Heller, and the court's invalidation of the District of Columbia's prohibition on having a functional firearm in the home, the court wasn't in a rush to hear more cases. It heard a case called McDonald versus Chicago, which applied that same right to the states, which was really a no-brainer, although it was a 5-4. In fact, I would argue as a constitutional matter, the outcome in McDonald was, more foreordained than even in DC versus Heller, because there's very little question that the 14th Amendment when the 14th Amendment was adopted, that one of the privileges or immunities of citizenship that it was protecting was the right of free citizens to protect themselves, and that it was understood at the time that free Black people would be able to protect themselves with weapons, and that was very much on the minds of those who drafted and supported the 14th Amendment, and that applies as against the states, where only the Second Amendment applies as against the federal government. After that, the court didn't hear a lot of cases about the Second Amendment, and that's been up until Bruin, and that's really been interesting. That you've had lots of litigation over guns, both constitutionally and increasingly in the administrative law context, and the court really had been avoiding them. There was this one silly case out of Massachusetts involving, I guess, stun guns, where the court vacated and sent it back and just said, it was basically, you didn't apply the right test. We're saying nothing else about what you did, but at least apply the right test.
Which was about Massachusetts had said stun guns aren't protected by the Second Amendment because they didn't exist at the founding.
Right, which is just goofy, right? And clearly, as an academic or as a professor that grades students, it's like you answered the question without having done the reading. Was essentially what the court was saying to this,
and that was a 9-0 ruling.
But what's interesting is now, as the court's done, the court had been avoiding gun cases. The court overall is taking far fewer cases, so it's only heard argument in 61 cases this term. That's the smallest in years. When I started as a professor, the court would routinely hear over 100. You go back to the 80s, there are terms where it heard 150, 160 cases a term, only hearing 61. And yet we have this explosion of gun cases, right? We have Bruin from just a couple of years ago. This term, we have the bump stock case, and we have Rahimi. So both an administrative law case and a constitutional case involving guns. And then the court has thus far only accepted 4 cases for next term so far. That's way behind what we would normally expect. And of those 4, one of them is another administrative law related gun case, a gun case which, as we'll get into, I assume, could be affected by what the court does in the bump stock case in terms of what the court says about how to interpret the language in statutes relating to guns, and also could be affected by what the court does in a case called, a pair of cases called Relentless and Loper Bright, which deal with something called the Chevron doctrine, which is a rule about how courts review agency interpretations of statutes. And that could affect this case too. So it's plausible to me that this court case ultimately gets remanded in light of what's done in these other cases. So it's just interesting that the court is, while it's hearing so much less, it's devoting more time to gun-related questions than it has in a long time. And the assumption the natural assumption is that has something to do with the change in the court's composition in the last few years, that it's now willing to say, look, we've got to deal with these cases because they're coming up, they're being argued in the lower courts, people are being prosecuted, people are filing these challenges. We need certainty and we need consistency across the federal system. And so we're getting a lot of attention to guns in given how little the court's doing.